So I thank Mr. Murarka and his entire team for having taken unrelented efforts in organizing webinars like this. Because in times like this, where we are facing an unprecedented situation and crisis because of COVID-19, as a fraternity, we have to create an opportunity for all of us. And through this, we can learn together. Today, I am going to speak on cross-examination in criminal trials, a topic which is very close to my heart. Now, in order to succeed in the art of cross-examination, I certainly the knack of communication. Because as a cross-examiner, we have to ask questions which are not vague, which are not ambiguous, and which are not open-ended. And therefore, it is very essential that we also master the art of communication in order to succeed eventually in this skill of cross-examination. And in respect of this, I am reminded of an anecdote which I would like to share with all of you. So in 1923, a lady ran to a London telegraph office and she informed the operator over there that her husband has gone to America to have a banner made for the Church of Scotland. However, she forgot to tell him the size of the banner and she wanted to convey it to him through this telegram. Accordingly, a telegram was sent and it was like this: "Dear Andrew, a son is born to us, 2 feet long, 8 feet wide." Andrew never returned back to his wife. The point is that she wanted to communicate two things to her husband. Number one, that a son is born to them, and number two, size of the banner. However, the way it was communicated, Andrew got a shock of his life and he never returned to his wife. Therefore, the point that I'm trying to draw home is that we must also sharpen our skills of communication so that we can phrase our questions very well when we have to put those questions to our witnesses. It is said, he who knows the art of cross-examination knows the skill of advocacy. Of all the accomplishments as an advocate, cross-examination is the most useful but most difficult to acquire. Friends, there is no precise mathematical formula as to how to succeed in cross-examination. It takes a lot of experience, hard work, and determination. I believe that cross-examination is a sword of offense, sword of attack, and a shield of defense. It is rare, friends, to come across testimony of a witness which does not have embroidery of untruth to it. And therefore, as a cross-examiner, our principal objective and duty is to separate the grain from the chaff. I'm reminded of a very old Sanskrit couplet: "Satyam bruyat, priyam bruyat, na bruyat satyam apriyam," which means that a man must always speak the truth and truth alone. However, often we see that witnesses who come to testify in courts of law on oath do not tell the entire facts. There is always element of suppression of facts, exaggeration of facts, and distortion of facts. And in such a situation, it is only through an effective cross-examination that we can expose falsity and help the court to reach to the logical conclusion of the case. It is often said that cross-examination is an art, but I also believe that there is a science behind it, because there are certain objective principles that one must keep in mind while one is undertaking the exercise of cross-examination in courts of law. My endeavor today is not to speak on legal jargons, not to burden you with a lot of complicated facts. I'll try to keep it simple because I'm aware that a lot of our viewers would also be law students. And in this perspective, I have prepared a short PowerPoint presentation which I would share with you for the purpose of better understanding, and I'll start with that. Just give me a second. Just give me a second. I hope you're able to see the screen that I'm sharing.
Yeah. Yes.
So this is cross-examination in criminal trials. So I've tried to make it a little interesting and funny as well. We all, as when we were youngsters, we must have been inspired with Bollywood and Hollywood movies in order to select law as a field. Here you can see images of Damini, Jolly LLB, and some other and another movie. The point that I'm trying to tell is, and I'm sure all of you are already aware of it, that what they show in movies, which are courtroom dramas, are fictionalized court events. And what actually happens in court is completely different than what is being shown in such movies. Now, art of cross-examination is something that maybe somebody may get inspired after seeing that movies, thinking that this is how cross-examination is to be conducted. Let me tell you, this is not how it happens in real life. Now, this is an image of a movie क्योंकि मैं झूठ नहीं बोलता of Govinda. I think many of you must have seen it already. The scene, this is an image of a scene where Govinda puts his hands on fire and he runs towards the witness when he is cross-examining him to prove some point. Now, this is not what you should ever do in real courts when you're cross-examining a witness. And this is the image to tell you what not to do in a cross-examination. Because even if you try to do this, I am afraid that you may end up losing your sanat. So that's the point that I'm trying to tell you. So what is the purpose of cross-examination really? The principal purpose of cross-examination is to elicit the truth and to expose the falsity. In examination in chief, the witness is trying to tell his own story in his own way. In cross-examination, we have to bring out skillfully all that he deliberately forgot to mention, all that he aimed to say but he did not say, all that he suppressed and all that he slurred over. As a cross-examiner, we have to punch holes in the story of the eyewitness and create a doubt about his story, and also probably create a possibility about the existence of another story, so as to show that our client for whom we are appearing and whom we are defending might not be the one who is charged to have been committed the offense. So that's the primary purpose of cross-examination. Now, before we undertake cross-examination and before we undertake this exercise, it is very essential that we understand the relevant provisions of law. Chapter 10 of the Indian Evidence Act deals with examination of witnesses, wherein several provisions of law are discussed as far as examination of witnesses is concerned. I'll discuss with some of these questions, some of these sections eventually. Start with section 137 of the Evidence Act, deals with examination in chief, cross-examination and re-examination. Now, examination in chief means examination of a witness by the party who calls him. Cross-examination means examination of a witness by the adverse party. And re-examination means examination of a witness after the cross-examination by the party who calls him. So I'll give you an example about this. Suppose there is a state case, suppose it's a case of murder, where the prosecutor is appearing for the state government. Now, all the witnesses that are summoned by the prosecutor, who will be the prosecution witnesses, the prosecutor will take their examination in chief, the defense will cross-examine them, and if required, the prosecutor may re-examine those witnesses again. So that's the way evidence is led before a criminal code, Chapter 10 of the Evidence Act under section 37. Now, section 138 of the Evidence Act provides the order of examination, which naturally means that a witness has to be examined in chief first, then his cross-examination, then his re-examination, as I told you. Now, it is important to note that examination in chief must relate to the relevant facts of the case, but the cross-examination need not be confined or restricted to what the witness had stated in his examination in chief. The reason being that the entire purpose of cross-examination, as I said earlier, is to expose the falsity of the case of the prosecution. And in order to pick holes in the story of the prosecution, a cross-examiner, a defense lawyer, may have to cross-examine a witness from several angles on different aspects. So though examination in chief must necessarily relate to the relevant facts, cross-examination is not limited to what is being said by the This is an image of a movie of Rajesh Khanna where he's seen to be examining and cross-examining the witnesses. So I'll give you an example how a provision of law can be misinterpreted. Now, section 291A of CRPC provides that the report of an executive magistrate who conducts a test identification parade can be exhibited straight away. Subsection of 291A also provides that if an application is made either on behalf of the prosecution or on behalf of the accused to summon that magistrate who conducted the test identification parade, then the trial court will have to summon that magistrate to testify in court on his report of test identification parade. So friends, basically test identification parade is when a man is accused of an offense, the witness is called upon to identify among several persons whether he is the same person who committed the offense or not, and that is a test identification parade. And there is a report which is prepared under the guidance of the executive magistrate, which gets exhibited under 291A. So under subsection 2 of 291A, the procedure is that if an application is made, he has to be summoned. And in the case that I know, the advocate for the accused made an application to summon that magistrate who conducted the test identification parade. The learned trial court allowed that application, but with a caveat that the magistrate must be examined by the advocate for the accused as his own witness, and he must take his examination in chief and not cross-examination. Now, the logic behind this that was given at that point in time was that Section 137 of the Evidence Act defines examination in chief means examination of a witness by the party who calls him. Now, since this magistrate was being summoned at the instance of the lawyer of the accused, and therefore he becomes his witness, and therefore he has to take his chief and not cross. Now, this defeats the entire purpose why the magistrate was being summoned by the accused in the deposition box itself, because the advocate for the accused wanted to cross-examine him to bring on record the loopholes in his examination, in his test identification parade. Instead of giving him that opportunity, the learned trial court insisted that he should take his examination in chief. The matter was carried to Honorable Bombay High Court, and Bombay High Court set aside that order, saying that a magistrate has to be necessarily either a court witness or a prosecution witness, and he can never be examined as a defense witness. So that's how at times wrong interpretation of law will defeat the entire spirit of the provisions. So the next issue is contradictions and omissions by witness. Now, this is an extremely important aspect. In any criminal trial, the entire purpose of a defense lawyer when he is cross-examining a witness is to discredit that witness or to impeach his credibility of that witness. And one of the manners in doing so is under Section 145 of the Evidence Act, read with Section 162 of the Code of Criminal Procedure. Now, what is meant by an omission and what is meant by a contradiction? As the name itself suggests, omission means a witness, suppose, tells a particular fact on oath before the court, and when the same fact is not mentioned by him in his statement before the police under Section 161 of CRPC, that amounts to omission. And what is meant by contradiction? Similarly, when a witness tells a particular fact before the police, when his statement was recorded under Section 161 of CRPC, and when that very witness, when he is called to depose in court on oath, he says something which is completely contradictory to what he had stated earlier, that amounts to contradiction. Now, it is not every omission and not every contradiction that matters in a case or in a trial. Only material omissions and material contradictions which really go to the root of the matter will be taken into note of in order to discredit a witness or to impeach his credibility. So we must remember in our mind that you may have thousands of omissions and thousands of contradictions, but if they are not material, if they are not significant, they will not fetch you anything. However, even if one contradiction which is extremely significant and important in nature, that will help you to discredit the witness under Section 155 of the Evidence Act. Now, what is Section 145 of the Evidence Act? Section 145 of the Evidence Act prescribes the procedure as to how contradictions can be proved in courts. So the section reads as follows: a witness may be cross-examined as to previous statements made by him in writing or reduced into writing and relevant to matters in question without such writing being shown to him or being proved. But if it is intended to contradict him by the writing, his attention must, before the writing can be proved, be called to those parts of it which are to be used for the purpose of contradicting him. So Section 145 defines the procedure as to how contradiction is to be brought on record. Section 162 of CRPC has to be read in consonance with Section 145 of the Evidence Act. Now I'll pause here for a moment. Under Section 161 of CRPC, what does it provide? It provides that when a police is investigating a crime, they will record statements of any persons who are aware about the facts of that crime, and their statements so recorded will be recorded under provisions of Section 161 of CRPC. Now, Section 162 of CRPC says that all those statements that are recorded by the police under Section 161 cannot be used for any purpose except for the purpose of contradicting those witnesses in case those witnesses come to court to testify on oath. Only then the use of those previous statements can be made, and that use and the procedure is provided under 145, and use of those statements is under Section 162. So we'll just go through the section for a moment. No statement made by any person to a police officer in the course of an investigation under this chapter shall, if reduced to writing, be signed by him, nor shall any such statement or any record thereof, or whether in a police diary or otherwise, or any part of such statement or record be used for any purpose save as hereinafter. Now, subclause 2, provided that when any witness called for the prosecution in such inquiry or trial, whose statement has been reduced into writing as aforesaid, any part of his statement, if duly proved, may be used by the accused and with the permission of the court by the prosecution to contradict such witness as provided under section 145 of the Evidence Act. And if you see the explanation, it is provided that an omission to state a fact or circumstance in the statement referred to in subsection 1 may amount to contradiction if same appears to be significant in nature. So, an omission amounts to a contradiction only if it is significant and material in nature. A contradiction per se has to be proved under the provisions of section 145 of the Evidence Act. Now, as I said earlier, only material contradictions and material omissions. I'll elucidate further by giving you an example. Suppose there is a case where a witnesses an incident where accused number A inflicted stick blows to the victim and accused number B assaulted by fist and kick blows to the victim. Now, statement of this witness is recorded under section 161 of CRPC, and he says as above that A inflicted by stick blows and B by hands and kicks. Now, when this witness comes to testify in courts of law, he takes a stand and on oath he says that it was accused number B who inflicted stick blows on the victim, and he makes no reference or whatsoever about the role of accused number A at all in his deposition before court on oath. Now, as a cross-examiner, it is our duty to bring on record these major contradictions and omissions because it goes a long way in discrediting this very witness. And how do we do that? As a cross-examiner, the first question that we will have to ask to this witness is, after having asked the general questions, the first question that we need to ask regarding this contradiction aspect is, did it happen that accused number B assaulted by hands and kicks to the victim? Now, the reason for asking this question is that because this witness in his 161 statement had stated that it was B who assaulted by hands and kicks. And now before court, he's saying that B assaulted by stick and not by hands and kicks. So you have to ask him, did it happen that accused number B assaulted by hands and kicks to the victim? He will naturally say no, he assaulted by stick. Then next question is, was your statement recorded by the police? He will say yes. Was it recorded as per your narration? He will say yes. Is police at loggerheads with you? He will say no, they are not. Then we have to invite his attention to that portion of his statement which was recorded by police under 161, where he says that accused number B assaulted by hands and kicks. And after we invite his attention to that portion of the statement, we have to ask him as to what he has to say about this contradiction, because in court he's saying that B assaulted by a stick, but before police he had said that B assaulted by hands and kicks. He may say he doesn't know, he may say it is being wrongly recorded, whatever explanation he gives, then we have to give him a suggestion. So we have to stop there. It is very important that when the witness on oath does not speak about accused number A at all, then we should not even ask him a question about accused number A, because inadvertently and out of enthusiasm, we may ask him that you had said before police that accused number A assaulted by stick. The moment we do that, we admit inadvertently the presence of accused number A at the scene of offense, which we should not do. If the witness does not speak about accused number A at all in his deposition on oath, we should not touch that aspect. Now, after we bring to his notice his contradiction and after his discharge as a witness, the investigating officer will come to testify. Now, we need to ask to the investigating officer as to whether the statement of this particular witness was recorded as per his narration. The investigating officer will say yes. Then whether he had stated it before you that accused number B assaulted by hands and kicks, the investigating officer will say yes. And then we have to mark that contradictory portion of his statement, which will then be exhibited. And at the time of final arguments, we'll have to argue before the court of law that, look, here is a man who is flip-flopping, whose memory does not support him. At one point in time, he says B assaulted by hands and kicks. And in court on oath, he's saying that B is assaulting by stick. So no trust can be placed upon such untrustworthy witness, and he is worthy of rejection. And that is how you discredit or impeach a credibility of a witness under section 155 of the Evidence Act. So that's contradiction and omission, which is an extremely important aspect in a criminal trial, because that is one of the major things that a cross-examiner has to do in order to falsify a version of a witness by creating doubts about his story that he had stated before court on oath. Now, our Supreme Court in the case of Vadivelu Thevar versus State of Madras had held that witnesses can be classified into three categories: wholly reliable, wholly unreliable, neither wholly reliable nor wholly unreliable. If despite all your cross-examination, the court holds that the witness is wholly reliable, then we are done and dusted. Our client awaits the conviction. If we are able to show that the witness is either wholly unreliable or neither wholly reliable nor wholly unreliable, then we stand a chance of getting an acquittal from the court. Now, suppose a witness falls in category 3 after your extensive cross-examination. The witness is neither wholly reliable nor wholly unreliable. In such a situation, the court will have to be circumspect in accepting the evidence of such witnesses, because the court then ideally will have to look for corroboration in material particulars in respect of such witnesses. It is important to remember that under section 151 of the Evidence Act, a cross-examiner cannot ask questions which are scandalous in nature, which are obscene and indecent in nature, and at the same time, under the garb of cross-examination, we cannot get into a fishing expedition or a fishing inquiry. That's prohibited. Moving to the next slide. Now, it's very important to understand the definition of proved as defined under section 3 of the Evidence Act. A fact is said to be proved when, after considering the matters before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. So friends, what does this mean? It means that according to section 3 of the Evidence Act, if the evidence is such that a reasonable and prudent man would believe that a fact exists, then the court shall hold that the said fact exists. So as a cross-examiner, we have to ask two questions to ourselves: whether the story that was tendered by the prosecution witnesses is natural and probable, number one. Number two, whether it is supported by different circumstances, including the subsequent conduct of the witnesses concerned. As a cross-examiner, we have to see to it that we are able to establish that the facts that are deposed by the witnesses in courts of law through our cross-examination, be able to show that they do not inspire the test of reasonable and prudent man, that the facts stated by them are something which cannot appeal to the reason of a prudent man. Because if that is so, then it will mean that the prosecution is not able to establish or prove the facts as defined under section 3 of the Evidence Act. And therefore, it is very essential that we understand and keep this fact in mind. See, law is nothing but codified logic, and section 3 also supports that claim, because section 3 says that anything that appeals to the prudence of a reasonable and prudent man about the existence of a fact, then the court will also consider that the said fact exists. And as a cross-examiner, our endeavor should be to show it to the court that the story that is being narrated by the prosecution witnesses is highly unreasonable and it cannot be relied upon. One of the important aspects of cross-examination is where to stop and what not to ask. Cross-examiner, it is very essential, must know these two things. You may not know from where to begin, but you must know where to stop. One may not know what to ask, but one must know what not to ask. It happens on several occasions that we get tempted to ask a lot of questions to our witnesses. And because we surrender to our temptation, we end up spoiling our case and also spoiling the future of our client. So it is very essential that we control ourselves and do not ask questions which are unnecessary in nature, and we also stop when it is so required. There is a famous Latin maxim, volenti non fit injuria, which means that if a man invites trouble, then he cannot complain about it. Similarly, unintended questions, the answer of which we can never anticipate, the answers of which we did not even think, should never be asked. we should never test the witness because we think that this is a question that we should ask for the sake of asking. We need to know the line of questioning that we have to put to the witnesses. If we invite the trouble by asking questions, the answers of which may damage our case, then we cannot raise any alarm against it. It's like, "Aa bail, mujhe maar." And that's why this image of a bull hitting a man, because he invited the trouble for himself. So now, friends, I'll come to rules of cross-examination. I have tried to make it look a little interesting by borrowing some pictures from several movies. And at the end of it, when I'm going to take questions, please don't ask me the name of all those movies. I may not be able to answer them correctly. So now I'll come on rules of cross-examination, which I think one must always keep in mind in order to succeed in cross-examination. Rule number 1, always maintain a constant eye contact with the witness. If you stare into the eyes of a witness, you will come to know what is passing in his mind. The truth, the falsity, the hatred, the anger can all be easily noticed and understood in the eyes of the witness. So that's rule number 1. Always keep a constant eye contact. Rule number 2, always pay close attention to the voice of the witness, because it will help us to ascertain the mental position of that witness. If a witness is scared, his voice will tremble. If a witness is overconfident, it will also reflect in his voice. So we must also pay close attention to his voice. Rule number 3, we must carefully observe the body language of a witness. Often witnesses are tutored or they are lying. And it also happens very frequently that when a witness is saying something, he will often look at his own lawyer in order to gain some sort of approval from him as to what he is saying is correct or not. The moment this is happening too frequently, you know that the witness is either being tutored or he is lying on oath, and you know what is to be done next. So these are the 3 rules. Pay close attention to his voice, maintain a constant eye contact, and observe his body language. Now, this is an image from the famous movie, which I think most of you must have seen, Section 375. Akshay Khanna is seen to be following all these 3 rules to the T. And it seems he would be a good cross-examiner in real life too. So I'll leave it there. Rule number 4, always begin with a gentle smile. Witnesses are, after all, human beings. They like respect. Giving them respect will not lower ours. If in fact we start with a gentle smile and in a polite manner, we can take that witness in confidence and we can take him along with us. He would not even know that your intentions are hostile to him. So we need to have, lawyers also need to be actors in that sense. So always begin, even if you may be very furious, but please, when you start your cross-examination, please begin with a gentle smile, be polite with him, and you will win the court. Rule number 5, one should be mild with a mild witness. One should be shrewd with a crafty witness. You have to keep a tap on the witness the moment he enters into the courtroom, right from his body language, right from his eyes, his voice, his overall behavior. So if a witness is mild, you be mild with him. If he's aggressive, if he's being nasty, you try to be being shrewd with him. So that's rule number 5. Rule number 6, very important rule. Never ever threaten the witness. Only if you are Sunny Deol, you can afford to do that. So often we have seen lawyers intimidating their witnesses, threatening the witnesses. Often I have seen lawyers losing their calm, composure, control, self-control, because they are not able to get answers from those witnesses, and they start intimidating, start threatening the witnesses. It does not go well with the court. We are not playing to the gallery. In fact, we lose our credibility as a good lawyer if we start threatening the witnesses, if we start intimidating the witnesses. Now, this image is from the famous movie Damini, and where Sunny Deol is shown to be an angry lawyer. Of course, Sunny Deol can afford to do that because it's a dummy court. In real courts, please do not do that. Please, let's not threaten any witnesses. That does not go well with our reputation as good lawyers. Rule number 7, determine the order in which the witness is to be cross-examined. My experience tells me that witness usually comes prepared with the sequence of events that they have narrated in their examination in chief. And hence, in order to dislodge them and to take them by surprise, change the sequence of your questioning, change the chronology of your questioning, because then that will take them by surprise and perhaps they may get confused because they are already tutored. They know how things have to be answered and they have prepared some sort of chronology in their mind. But the moment you throw a spanner in it and you are able to dislodge them and confuse them, then perhaps they'll surrender to your good questioning. Rule number 8, witness should never get an idea as to the real objective of our cross-examination. If you are desirous of getting an answer, please do not ask that question directly to the witness, because it will fall flat. Because witnesses are not dumb people, they are also smart people. They will answer it if you ask a question directly to them. A series of questions, each leading up to the point, will get the job done. And the moment you get an answer that you want, leave it there. Do not again try to get that position further clarified, because you may lose an admission that you've got from that witness. And you should start to divert the mind of that witness by asking questions of no relevancy at all. Because there is a habit of lawyers I've seen, of certain, even my friends, that after having gotten a good admission from a witness, they would again try to address on the same issue. Witness becomes clever, he tries to rectify his mistake, and the admission that we have got also goes away. So always ensure that you do not disclose your real objective of cross-examination. Put series of questions, each leading up to the point, and that will get your job done. Rule number 9, our face should not be the mirror of our heart. Often I have seen people expressing anger, frustration because we are not able to get answers. We should not, if we got a good answer, we should not reflect joy on our face. We should not reflect happiness on our face. If we don't get a good answer, we should not be equally reflecting sorrow or frustration on our faces. Now, this image is from Jolly LLB 2, where you can see Akshay Kumar and Anu Kapoor expressing whatever is passing on in their hearts. You can see and read the intentions and expressions very clearly. The reason for this is, my friends, that witnesses, as I said earlier, are also smart people. As we are reading their faces, they are also reading our faces. And looking at our face, they will come to know whether they are answering it properly or not. So let's have a poker face. Let's not show anything to them. Let's show them that we are completely unaffected. Though deep in our hearts, we are knowing that we are not getting what we want. But let's not make our face the mirror of our heart. That's rule number 9. Rule number 10. If the witness decides to be witty, let him have an opportunity of satisfying himself, overestimating himself and underestimating our capabilities as a cross-examiner. So this is an image of a movie where Govinda is seen to be laughing. You can look at the faces of those two lawyers. They have maintained extreme calm, composure, poker face, not expressing, because they know that they will have their turn and they will grill this witness completely. So if a witness is trying to be witty, we need not get down to his level and start cracking jokes. We have to maintain our dignity as lawyers. Let him have his moment of wittiness, because the courts also don't like witnesses who act over smart. So as lawyers, we must maintain that distance, and we should not stoop or get down to the level that they bring themselves to. So that's another rule number 10. Rule number 11, very important. One must always learn to read the psychology of the witness. A child's psychology is different from a woman's psychology. A woman's psychology is different from an expert psychology. Therefore, it is very essential that we read the psychology of our witnesses well. And how do we do that? We do that the moment the witness steps into the court premises, and not just into the witness box. We start reading the witness the moment he steps into the witness boxes, and that's how we prepare ourselves for that witness. So these are 11 main rules that we must keep in mind when we undertake the exercise of cross-examination in courts of law. Now, cross-examination, as I said, is an art, but there are scientific principles behind it, which one must keep in mind. And this art also requires thinking on feet and 11th hour wisdom. And therefore, it is an important trait of any established cross-examiner, his ability to think on his feet and to have the 11th hour wisdom, so that we can change our questions depending upon the answers that are being given by the witnesses, even on the 11th hour, even though we are not prepared about that answer. However, if we utilize our wisdom well, then perhaps we can get around that situation also. Now, it is very important when we are preparing for cross-examination, we must know the facts of our case completely. We must know the statements of all the witnesses that have been recorded under section 161. We must know all that witnesses, including eyewitnesses, punch witnesses, other witnesses, if the case is based on circumstantial evidence, witnesses on circumstantial evidence, what all these witnesses have stated in their statements before the police under section 161, because only then we know what we have to ask to any particular witness. Also, in a case where there are several eyewitnesses, through the cross-examination of one witness, we must try to demolish the version of other eyewitnesses. so that when those eyewitnesses come to testify in courts, eventually we can bring on record their inherent inconsistencies between the version of different eyewitnesses. So these were the rules and these were the principles of cross-examination. Now, I would like to discuss few cases with you on about how I have seen and experienced some good cross-examinations, and I think you will also benefit from that. So there was a case, as I said earlier, that we must always understand the psychology of a witness. I know of a case where a man was accused of having killed his own daughter who was 10 years old. He was an agriculturist. The incident took place in his own agricultural field, where this man pushed his daughter on a stone and she died. The incident took place in his own field. And the only eyewitness to that incident was his own son, who was 8 years old. The man was prosecuted for offense under section 302. The wife of that man left him, deserted him, and even the son went away with his mother. As I said earlier, the only eyewitness was the son, and he was not going to support his father. He was hostile to the interest of his father. So when this case stood up for trial, the cross-examiner went to inspect the scene of offense. Now, it's very important as a cross-examiner, before we undertake any cross-examination, we must visit the scene of offense so that we know and we can construct what must have happened over there. And we can play it in front of our eyes to understand the situation better. So this cross-examiner visited the scene of offense and he understood that from the place where this incident took place, there was a pond where this incident had taken place at around 5:30 in the evening. And this cross-examiner visited the scene of offense at the same time. And he saw that certain children were playing in water at around the same time in that pond, which was at some distance. So when he went to that place, when he went to that pond, he saw those children playing, jumping, enjoying in water, swimming in water. He waited there for some time. Then he tried to see whether the scene of offense, the place of incident, that is that agricultural field, whether it is visible from if one stands near the pond. And he could not see that. Nobody could have seen that. So he inspected the spot and he went back. When the case stood up for trial, the son naturally in his examination in chief spoke against his father, said that the father has committed the murder. He pushed his sister and she died because her head bumped onto the stone that was there. The cross-examiner asked certain questions here and there. And then the cross-examiner started asking him that, is it not correct that there is a pond near the place where this incident took place? The boy said yes. Then he said, I have visited that place, and is it not correct on every evening between 5 to 5:30, several children of your age go there for swimming? He said yes. Then the cross-examiner said this statement, and he said, I have seen that those children were enjoying a lot. They were jumping, swimming, dancing in water. Don't you know the swimming? The child was a little perturbed. He said, no, I do know swimming. He said, then the next question that he asked was there any special reason why you were not swimming on that day? Now you have to understand, the lawyer was playing on the psychology of this child. Naturally, when he was confronted with this, he did not want to be left out from other children, and he did not want to look timid. So he said, no, even I was swimming on that day. So then he asked again, so were you swimming when the incident took place between 5 to 5:30 with those boys? He said, yes, I was swimming on that day. The cross-examiner stopped there, because he knew that if he would have asked any further questions, it may have spoiled the case. After he stopped there, the prosecutor stood up and he sought permission to re-examine that witness again. And he tried to grill that witness on every angle, tried to tell him that just now you, in your examination in chief, you said that you saw the incident of your father committing the murder and you were swimming there. This is a wrong statement. Despite all his efforts, the child was not willing to come out of the water at all. The reason was that because this cross-examiner played on the psychology of that child. And if we understand the psychology of that child, then we can come to know that children normally would not want to do something different. They would want to do what everyone else of their age is doing. And since those boys of his age were swimming regularly, he also wanted to be in water at the same time. So that's one of the examples. But at the same time, we must know that in order to cross-examine a witness, we have to also know the relevant provisions of law. Now, in a case, I'll give you an example, another example. A man is accused of having committed murder of his own wife because he suspected that she was in an extramarital relationship. Now, when this incident was committed by him, he sustained an injury to his hand, but he was extremely repentant as to what had happened, and he was overpowered by grief. So he straight away went to the police station and confessed about having killed his wife. Police immediately arrested him, recorded the FIR, and since he had sustained an injury to his hand, he was sent for medical examination, which is the normal practice. When the doctor asked him as to the history of this injury that he had sustained, he again, because he was in a lot of grief, lot of repentance, regret, he again said that I have committed murder of my wife, and he gave, so to speak, an extrajudicial confession to the doctor. Then the investigation was completed, charge sheet was filed, he was put on trial. Now, it is very important, what I'm trying to tell you is that not in every cross-examination we need to ask lengthy questions or too many questions. If we know what is to be asked, and if we know the relevant provisions of law, then even in shortest possible cross-examination, we can get an order, we can get a judgment of acquittal. So in this case, when the doctor stood up for when the doctor came in the witness box to depose, the lawyer, the cross-examiner, asked him 2-3 irrelevant questions, and then he asked him only one question of relevance, which was, is it correct that when this accused gave an extrajudicial confession to you, there was no one else present apart from you and this accused? The doctor said, yes, only both of us were there. That's it. He stopped there. He didn't ask him any further. Then when the investigating officer came, the cross-examiner asked only 2 questions and nothing else. The 2 questions that were asked to the investigating officer were, is it correct that when the accused was sent for medical examination, he was in police custody? The investigating officer said, yes, he was in police custody. Second question, is it correct that when he went to the doctor for his medical examination, apart from him and the doctor, there was no one present, and even not a magistrate was present at that point in time? The investigating officer said, yes, there was nobody present. Only the doctor and only the accused were there, and my policeman. So that's it. That was the cross-examination. Now, when this matter came for final arguments, only 2 minutes of arguments were advanced before the court, and they were that Section 26 of the Evidence Act says that if an accused is in police custody, then any confession given by him is inadmissible unless it is made in immediate presence of a magistrate. So when this extrajudicial confession was given by the accused to the doctor, the accused was in police custody, number 1, and it was not given in presence of any magistrate. And therefore, as per Section 26 of the Evidence Act, this extrajudicial confession cannot be accepted. It is inadmissible in the eyes of law. The man got acquitted. This was the shortest cross-examination that I've seen and shortest argument that I've seen. So the point that I'm trying to draw home is that in order to be a good cross-examiner, it is not necessary that we cross-examine at length. I would, in fact, in a case that I had conducted recently, where an MLA was accused of having assaulted a public servant. The case was that this deputy collector was a public servant. He was acquiring lands of farmers, and there was an agitation under the guidance of this MLA, and some incident occurred, and the MLA assaulted the public servant, and I was defending that MLA. So there were 2 things that were in my mind that I have to establish, because the MLA was prosecuted for offense under Section 353, which is assault on a public servant while he is discharging a public duty. So there were 2 things on my mind. Number 1, I have to bring this case out of the ambit of Section 353 IPC, and in order to do that, I'll have to show that when the alleged incident occurred, the complainant, the victim, the public servant, was not discharging his official duty. That's number 1. And number 2, I had to bring on record the omissions, contradictions, and the inherent inconsistencies. So when I cross-examined the deputy collector, the complainant, I brought on record all the contradictions, all the omissions, including the angles of delay, because this FIR was launched by the complainant at a belated stage after a couple of days, and he was frequently going to his office in meanwhile. So I brought all these aspects on record, which was his contradictions, omissions, and through other eyewitnesses, I try to bring on record the inconsistencies between the versions and theories of eyewitnesses. The learned trial court accepted my submissions and eventually acquitted the accused. So the point is that as a cross-examiner, we have to attack from all the angles. It's not just one angle. It's not just one line of thought. We have to prepare from the perspective of the prosecution. We have to prepare from the perspective of the accused, and we have to also prepare from the perspective of the witness. It is only when we combine all these three angles that we would be able to succeed in the art of cross-examination. I wouldn't take much time. This brings me to the end of the discussion. Well, you all were a fantastic audience. It was a pleasure to speak and address you all. Only one request at the end. So only one request to all of you, that with this enhanced skill of cross-examination, please do not use these skills on your respective spouses in this period of lockdown, because you may never know how that trial may end. Thank you very much.
Mr. Nikam, I had two questions, if you don't mind.
Sir, instead of asking directly to Aniket sir, can you drop message in a message box? It will be easier for Aniket sir to answer.
Sure.
Yeah. So, yeah, please tell me.
Sir, actually, typing would take some time. It's very short, if you don't mind.
Tell me.
Sir, as a matter of rule, you said never intimidate the witness.
Yes.
And as we have seen in American trials, perjury is something which is very seriously taken. However, in Indian courts, in my limited experience, people don't shy away from lying. So is it a form of intimidation if you remind a witness of a punishment which he may attract in case of perjury?
No, see,
and how do you get a witness to tell the truth? I mean, his conscience is not going to enforce him. So I mean, just
see, there are two things. If a witness is lying, or if a witness is not being truthful, and that is why you need to have a good skill of cross-examination, because you have to attack, in that sense, a witness from all angles. Now, the reason for saying that you should not intimidate a witness is this. See, these witnesses are not children. If you intimidate them, it would not mean that they'll succumb to your pressure or to your anger and they'll start speaking the truth. But what happens is, if you start intimidating the witness, it does not go down with the court, well with the court. And even the courts may admonish the lawyer and tell the lawyer to behave properly and to follow the decorum of the court. Now, if a witness is lying on oath, and if you know it for sure, if he is lying on oath, then of course you can prosecute him for perjury. And suppose a witness is there to lie on oath, it is your skill of cross-examination to bring on record the contradictions and improbabilities in his evidence. Now, as I said earlier, section 3 defines proof. Now, the test is that of a reasonable and prudent man. If his evidence appeals to the reason of a prudent man, then the fact is said to be proved. Now, if a witness is lying and if he is exaggerating a situation, no court is going to believe that. And you will have to bring out on record the contradictions and omissions that are there from his previous statements and what he is being stating on oath before the court.
yes, thank you.
So I hope I am able to answer your question. So I have another question from Ashish Gupta. How do you take out the MLA who was charged under section 353? So it was a very detailed cross-examination which went on for a couple of hours. I'll share the judgment with you. My email ID is with the host, so that I'll email it to you so that you can get it. It was a very detailed cross-examination in order to show that this meeting was never actually within the domain of his public duty.
Okay, anyone has any question? Okay, I think so. No one has any question.
No, I was just wondering if there was any specific book that you would recommend to all of us.
There are several books on arts of cross-examination.
Very well. So anything specific?
What I would really recommend to you. I do not know.
Hello, you can hear me?
Can you hear me? Hello.
Yes, we
Hello?
can. We can, sir.
Yeah. So what you should try and do is actually you should attend trials and you should see how cross-examinations are conducted. Because by reading books, it's difficult to understand this art. It is only when you witness yourself personally that you will get to know a hang of it. So I'll suggest that you go in person and attend some good trials and actually see how proceedings take place. And that is how you will understand. And
Very well, sir. Thank you.
Hello.
Thank you, sir. Yeah.
thank you.
Okay, so Aniket sir,
Yeah, thank you.
thank you so much for enlightening us on today's topic.
Thank you. It was a
We are
pleasure.
sure to have many more sessions, and this continuous learning program will continue, and we will be adding more value from time to time for lawyers and law students to lift our legal profession to new heights. I also thanks to all the participants. I know that there was some noise and there was some disturbance in starting, and hope that we don't make such mistakes in coming session. And thank you so much,
So we are really
sir.
also thankful for making
This
it so
meeting was
interesting
really wonderful.
with
And
all the Bollywood images and references to movies and the actual cross-examination. It was really interesting.
Thank you, Mr. Moore.
I think that's my English.
Thank you.
Hello.
Thank you, sir.
Thank you. Thank you very much.